Hello, everybody. Stephen Avery has wrote the Wisconsin State Legislature on the 24th of March. It was filed to the Wisconsin Legislature from Stephen Avery, filing complaint. The State Commission on Judicial Conduct reprimanded Judge Angela W. Sikowitz for exceeding the scope and authority of her office and for failure to comply with the law. Judge Angela Sikowitz, she turned a blind eye to much of the evidence and also refused to admit probative admissible evidence that, when evaluated on the proper standing, is damning. Judges, Canon 1, 2, 3, 4. A judge shall uphold and promote the independence, integrity, and impartiality of the judiciary and shall avoid impropriety and appearance of impropriety. A judge shall perform the duties for a judicial office impartially, competently, and diligently. A judge shall conduct the judge's personal and extrajudicial activities to minimize the risk of conflict with the obligation of judicial office. A judge or candidate for judicial office shall not engage in political or campaign activity that is inconsistent with the independence, integrity, or impartiality of the judiciary. State of Wisconsin, the State Commission on Judicial Conduct reprimanded John. That's the same thing. All right, here we go. The judge is behaving badly. A judicial misconduct refers to the acts that are unethical, illegal, or in violation of the judicial obligation, impartially, as we've seen. There are myriad ways in which judicial misconduct rears its tainted head more often than not. Such misconduct is subtle, sometimes it is blatant. The 14th Amendment secures the right to due process. The 8th Amendment prohibits the use of cruel or unusual punishment during arrest or detention. These rights can be violated by the use of force amounting to punishment. The person accused of the crime must be allowed the opportunity to have a trial and should not be subjected to punishment without having been afforded the opportunity to the legal process. Fact-based evaluation of the weight of evidence in a claim. Fail to keep from harm. The public counts on its law enforcement officials to protect local communities. If it's shown that an official willfully failed to keep an individual from harm, that official could be a violation of the color of law statute and the truth of justice. Reached by actor framed for murder. How important is the question of innocence to a judge? Judges who rejected over and over his or her claim that he was a victim of police and prosecutorial misconduct, and his exoneration didn't matter to the Wisconsin court that rejected his estate's claim for compensation for his wrongful conviction for the second time. Ruled that an attorney rendered ineffective assistance of counsel by not telling me nothing at all as attorneys Dean Strang and Jerome F. Buting. I told them all the evidence back when I had them, and they didn't do nothing at all. They keep telling me that the state did it, all of it. And if they would have did their job, I won't be in here. If they would have listened to me, they would have not won my case for the truth. If they would have investigated my case, but they didn't do. No investigation on my case at all. And Dean Strang and Jerome Buting, the lawyers, admits they were ineffective in Stephen Avery's trial. The mishandling, misrepresentation, and they regard to discharge juror that they were to have a record in court and they were sitting in a restaurant eating and drinking liquor and they told the judge to let the juror go. And that was against the statute and law. And Bobby's computer and all the Brady violations that they didn't do for me. And Dean Strang and Jerome Buting were working for the DA, Kenneth Kratz. They would always listen to them and not their client, Stephen Avery. Dean told Jerome not to tell me nothing at all on my case, and that is not their duties for their clients. Circuit rules abuse discretion from the fail to conduct evidentiary hearing on Brady claim and conflict of interest claim. To establish the Brady violation, a defendant must show 1. The government withheld evidence, 2. The evidence was favorable because of impeachment value, and 3. The withheld evidence was material. For evidence to be material, it is required only that there is a reasonable probability that the outcome of the proceedings would have been different if the evidence had been disclosed. Because only the prosecution alone can know what was undisclosed, a petitioner need only make a prima facie. This is Stephen Avery writing this, so he is not spelling words correctly, so I'm trying to do this the best I can. Showing of a Brady violation in order to obtain an evidentiary hearing. A lower court abuses its discretion when it denies an evidentiary hearing after the prima facie showing has been made, the claim is not otherwise procedurally barred, or if the factual allegations are not contrived by existing record. Circuit Court erred when it failed to convey its evidentiary hearing. He should have proofread this before he sent it in. A petitioner claiming a conflict of interest must prove 1. Multiple representation that created an actual conflict of interest that adversely affected the lawyer's performance, claimed by showing the attorney failed to pursue alternative strategy that A. could have benefited the instant defendant and would violate the attorney's duties to client. Justice and judges and municipal judges. Oath of office and eligibility to other office. Salary, conservators of peace. Every person elected or appointed justice of the Supreme Court, judge of the Court of Appeals, judge of the Circuit Court, or municipal judge shall take, subscribe, and file the following oath, state of Wisconsin. Count of I, the undersigned, who have been elected or appointed to the office of, but have not yet entered upon the duties thereof, do solemnly swear that I will support the Constitution of the United States and the Constitution of the State of Wisconsin, that I will administer justice without respect to persons, and will faithfully and impartially discharge the duties of said office of the best of my ability, so help me God. The judge of any court or record in the state shall be eligible to hold any office of public trust except a judicial office during the term for which he or she was elected or appointed. The judges of such courts shall be conservators of the peace and have power to administrate oaths and take the acknowledgement of deeds and other written instruments throughout the state. Powers of courts. Several courts of record of this state shall have power to administrate oaths of the witnesses in any such matter of cause, or in all other cases which may be necessary to exercise the powers and duties of such court, to devise to make such rights and proceedings as may be necessary to carry into effect the power or jurisdiction possessed by them, to exercise any of the power or duties of the Circuit Court Commissioner. Substitution of judge. When the clerk receives a request for substitution, the clerk shall immediately contact the judge whose substitution had been requested for a determination of whether the request was made timely in a proper form. If the request is found to be further timely in proper form, the judge named the request has no or another judge under 7503. If a judge named in the substitution request finds that the request was not timely, and judge of the Judicial Administrative District, if the judge named in the request is the chief judge, if the party who made the substitution request files a written request for review with the clerk no later than 10 days after the determination by the judge named in the request. If the determination is made by the judge matter to the chief judge of the Judicial Administrative District or held the chief judge or the adjoining Judicial Administrative District. If the judge named in the request is the chief judge, the determination of whether the request was made timely and in proper form, reassignment is necessary. Newly assigned judge shall proceed under Statute 802.0.10. Manitowoc County Circuit Court took me out of my jurisdiction and my district for a substitution of judge, and I do have 3 judge in my county, and I should have stayed in my own jurisdiction, in my own district, and I should have a hearing on this motion at the time when I put this in. The case is 05CF381, and they gave me Honorable Judge Angela Sukowicz, Judge presiding, from Sheboygan, Wisconsin. I should have stayed in Manitowoc County, not in Sheboygan. The legislative findings in 2007 Wisconsin Act 1. The legislature finds that providing under 2007 Wisconsin Act 1 for the place of trial in the county where the offender resides is consistent with the legislature's authority under Article 1, Section 7 of the Constitution, in which previous acts by the legislature providing for the place of trial in counties other than where the elements of the offense may have occurred. The legislature further finds that allowing defendants charged with violating the offenses covered by 2007 Wisconsin Act 1 to request a trial in the county where the offense occurred is consistent with the protections in Article 1, Section 7 of the Constitution. The legislature finds that the violation of offenses covered by 2007 Wisconsin Act 1 are violations of the public trust that should have been adjudicated in the county where the offender resides, so the individuals who the defendant interacts with daily, serves, or represents as a public official and candidate with those trusts was violated by the offenses will judge the defendant guilt or innocence. The legislature further finds that no to so provide is consistent with the equal protection of laws under Article 1, Section 1 of the Constitution. The legislature finds the venue provision in 2007 Wisconsin Act 1 represents an appropriate balance between the rights and the defendant, the need to prevent and prosecute civil and criminal offenses covered by 2007 Wisconsin Act 1. I should have a new trial and all the new evidence. This circuit court abuses discretion and summarily dismissing Mr. Avery's second motion pursuant to Wisconsin Statute 97406 without addressing the 5 Brady claims raised and has subsequently denied Mr. Avery the motion to supplement which raised a 6th Brady claim, all of which deprived him of due process in violation of Wisconsin and United States Constitution. The standard review: Brady violation for Mr. Ramlow, Brady violation for Mr. Radant, Brady violation in the original flyover video taken on November 4th, 2005, Brady violation in the zipper voicemail, Brady violation in Mr. Heidel, Brady violation in the Dassey John CD, computer that Bobby Dassey was using, and it had all the stuff on it to access violent images of young deceased females, rape, torture, incest, pedophilia on the internet at the times when only Bobby was home. And he had a picture of Teresa Halbach and Stephen Avery, and this looks like a good suspect to this case. And the new eyewitness, Thomas Sawinski. Mr. Sawinski was a motor route driver for the Gannett newspaper Incorporated and delivered papers at Avery Salvage Yard early morning hours of November 5th, 2005. Prior to delivering the newspapers at Avery Salvage Yard, he turned onto Avery property and witnessed 2 individuals, a shirtless Bobby Dassey and an unidentified older male, subsequently pushing a dark blue RAV4 down Avery Road towards Junkyard. The RAV4 did not have its lights on after Mr. Sawinski drove by Bobby and the other individual and delivered the papers to the Avery mailbox. He turned around and drove back towards the exit. When he reached the RAV4, Bobby attempted to step in front of his car to block him from leaving the property. Mr. Sawinski was within 5 feet of Bobby, and his headlights were on Bobby during the entire time. Mr. Sawinski swerved into the shallow ditch to escape Bobby and exit the property. After Mr. Sawinski learned that Teresa Halbach's car was found later in the day, on November 5th, 2005, he realized the significance of what he had observed and immediately contacted the Manitowoc Sheriff's Office and spoke to a female officer, reporting everything he had stated in his affidavit. That was the 8th Brady violation the state held. The Brady number 7 in the violation due process destroyed evidence. The issue remanded at circuit court was whether the state violated Youngblood v. Arizona and Wisconsin Statute 968-205, when it returned the human bones to the Halbach family in 2011 without giving notice to Mr. Avery or his counsel. Mr. Avery's supplemental 97406 motion alleged material facts sufficient to establish a violation of Wisconsin Evidence Preservation Statute, Wisconsin Statute 968205, and Youngblood, because the 968205 does not provide a remedy for convicted persons in the event of a violation. Fashioning remedy is left to the courts, and an action Wisconsin courts have yet to make. Mr. Avery's supplemental 968205 motion contains sufficient material facts for the circuit court to fashion a remedy for such evidence preservation violations. Controlled by the United States Supreme Court President addressing evidence preservation violations. California, Youngblood, Arizona, Chamba, Youngblood comprise of the line of constitutional jurisdiction and outlines the extent of the state's duty to preserve evidence. If the criminal defendant can satisfy either test, then a court will rule the destruction of evidence with a violation of due process, reverse the defendant's conviction. The Due Process Clause of the 14th Amendment of the United States Constitution imposes a duty stated to preserve the exculpatory evidence. Failure to preserve evidence violates the defendant's due process rights if police fail to preserve evidence that is apparently exculpatory or acted in bad faith by failing to preserve evidence that is potentially exculpatory in State versus Greenwood. Evidence-based criminal justice. The criminal justice system is broken and it has to be fixed. And this is the time to fix it and get it right, because I'm a victim of a setup and it has to be fixed now. Yeah. I don't know if this is going to do anything for Stephen. He has way more evidence to grant him a new trial, but the state of Wisconsin this is political. There's too many people involved now. This is, once Stephen does get his new trial, this is going to ruin the state and everybody involved, all the way up to Judge Sikowitz, including the State Attorney General, Peg Lockenslaughter. So, yeah. So, unless some new news comes up in Stephen Avery's or Brennan's or Colborn's, I'll see you guys next time.